All right, good afternoon, everyone. This is the House Judiciary Non-Civil Committee. We're here for a hearing on House Bill 954 by Representative McKillop of the 115th. I sent out a notice just to make sure it's clear. On the more highly charged bills, sometimes take more than one hearing, more than one day. Could take 2 days, more, just depends on the issue. We run a very open and very even-handed process. What we generally do, I think what we always do actually, is we hear from the author first, who will present the bill from beginning to end. Then we have at least one round of questions from members on the bill. It could be outside the bill. It just, we let the conversation and the discussion and the dialogue, and it really is a dialogue, just grow organically. That's the best part of the deliberative process. At that point, once we conclude that, my hope, of course, is to be able to complete that step today. That is when we would go ahead in the next meeting, in subsequent meetings, either singular or plural, and to hear public testimony, time to be equally divided between proponents and opponents. So with that, what I'm going to do is recognize Representative McKillop to just walk us through the bill. Well, I'll ask members if we could refrain from, we're going to refrain from questions until after he's completed his presentation, as opposed to going section by section. I don't think the bill is so long that it needs to go section by section. So we'll just let Representative McKillop get through it, and then we'll go back and individual members can ask questions. If we can limit it to a round, that would be great. But if we need to go into 2 rounds, that's fine. That's our tradition. We'd rather have more discussion than less. Are there any questions from members of the committee? Is there anything that I've been unclear on? Okay, Representative McKillop, let me make sure your mic is on. Is that it right there?
Thank you, Mr. Chairman. All right. Thank you. May it please the ladies and gentlemen of the committee. My name is Doug McKillop, House of Representatives, District 115. I bring before you House Bill 954, and I will, as the chairman suggested, simply go through the provisions of the bill, sort of try and illuminate some of the changes between current law and what this bill seeks to do. And then rather than going into any of the explanation about the constitutional law or the medical side of this bill, we'll open it up for questions and sort of organically let it go where it goes.
Let me just interject one thing just for members in the audience to understand. We have a hard stop at 3 p.m., just to make sure that's clear. We do have a hard stop at 3 p.m. for this room. If for some reason we're not through the rounds, we'll continue it next time. Just want to make sure that's clear for everybody's understanding. Sorry.
Yep, thank you. Beginning with the bill, Section 1 contemplates legislative findings, and I'm not going to sit here and read the entire bill to you. I know that everyone can read the bill, but it contemplates legislative findings, which basically say that by 20 weeks after fertilization, the legislature finds that unborn children can experience pain, that they have all of the development necessary to feel pain, to react to stimuli which we would consider painful, that they are regularly anesthetized when they have in-uterine surgeries, and that we, in this bill, assert a compelling state interest in the protecting the lives and the pain-capable aspect of unborn children from that stage forward. The compelling state interest is important when we get into the constitutional law discussion later. Section 2 very minorly modifies what is currently our criminal abortion statute. That is, we already have a criminal abortion statute, and it simply rearranges some of the language to add some of the definitions that appear later. It criminalizes third-party action, not the action of the pregnant woman. That is, it's always third party, and we've had cases on that in Georgia. It is a 1 to 10 year felony. That is at lines 35 to 36, so that the violation of this law would carry that punishment. If you go to 1612-141 at line 37, we strike that language and replace it, and not replace it, but modify it down below, and it basically says that no abortion is authorized in violation of 31-9B-2, which is in this packet at lines 107 to 114. that requires that says no abortion shall be conducted in violation of that provision, which requires a gestational age of the baby to be determined. So once you've determined the gestational age, we go back to what is currently the law in Georgia at line 44. That is no abortion unless it's in a hospital, a licensed ambulatory surgical center, or a health facility licensed as an abortion facility by the Department of Community Health. That's already law. Also by a licensed physician. Then when we get to line 50, we have sort of the meat of the changes. We got no abortion is authorized if the gestational age, which has obviously been previously required to be determined, is 20 or more weeks, except for the life of the mother, as that is defined in Georgia law at 55 to 60, or to preserve the life of the unborn child at 61. We did add some additional definitions, which are referenced there at 62 and 63, which appear later in the bill. Line 64 to 74 require that you terminate the pregnancy in a way that gives the child the best chance to survive if the child is capable of sustained life, if it is determined that the child is capable of sustained life. In Chapter 9b, which is an entirely new chapter beginning at line 85, we provide different definitions that are in different code sections for abortion, medical emergency, physician, probable gestational age, reasonable medical judgment, and unborn child. The definitions are important because obviously we use those terms throughout the rest of the statute. 31.9b, of course, is the part where you must determine the gestational age except in the case of an emergency. 31.9b3, there are reporting requirements that are already in place to a certain extent, and these just conform the reporting requirements for the physicians that perform abortions to the new law. That is, it requires them to add the additional information regarding gestational age, the type of abortion procedure, and what was the exigency or emergency that was required. It's a reasonably short bill. That being said, I can imagine that it will generate a fair number of questions. I think the important thing is that the state of Georgia is demonstrating and articulating a compelling interest in preventing what has been found constitutionally to be a living organism from experiencing pain past 20 weeks. That is, it would prohibit and outlaw abortions past 20 weeks, except in very limited circumstances. And it defines a more clear and bright line test other than viability, which is the current constitutional jurisprudence. I'm happy to stand for questions on the bill.
Let me ask you a question about the reporting requirement. Summarize, if you can, the contrast of the reporting requirement that exists today with the reporting requirement that would occur under this bill.
You would have to,
and the rationale for it.
You would have to include the gestational age and also the medical condition which required or necessitated the termination of the pregnancy. That is, since we would be making it illegal past a certain age, and also in the event the medical emergency existed in the doctor's opinion or in the medical opinion to allow the abortion, then we are requiring those two additional pieces of information, the age and why.
Okay. And I see the report as to DCH. Is that consistent with the reporting now, or is that? I know we have reporting now.
It may have recently been changed to. I'm not sure to what agency the reports are made. I know that the doctors' names are kept confidential no matter where they go. But yes, I'm not sure where they go right now.
Okay. I mean, I understand where you're going. I think to the extent that you can, if you're going to have a reporting requirement, if we have one right now that is to a certain agency and in a certain format, just for purely practical administrative reasons, if we could.
And DCA has touched base with me on that and has indicated that they would like to have some further communication on that, and I said I was open to any communication on how the reporting is to be done.
Okay. Is it you? Yes. Okay. Thank you. For members of the committee, we're obviously not in our regular room. This is the time where the Civil Committee meets, so I'm not used to the system here. So if I look down with a lost look, just put your finger up or something to let me know that it's you that wants to ask a question. Mr. Vice Chair.
Thank you, Mr. Chairman. Representative McKillop, I had a question on the paragraph C1 under 1612-141. It begins line 50 on page 2.
Yes.
And if you read that, it provides no abortion is authorized or shall be performed basically 20 weeks or later unless in reasonable medical judgment the abortion is necessary to, and then line 55 says A, avert the death of the pregnant woman, etc., and then on line 61, B, preserve the life of the unborn child.
Yes, that's correct.
Explain that.
Well, I guess the example would be if the mother was, God forbid, in a horrific car accident and was going to die, you would have to abort the child in order to save it.
I don't understand that.
I mean, let's say you're 23 weeks pregnant, or someone is 23 weeks pregnant and is in a horrible car accident and is slipping away, is going to pass away. If you leave the child within her, the child will necessarily die. At 23 weeks, there's a 15 to 20% chance you can save the baby. So there is a possibility or an example of when you might have to perform an abortion. That is, get the child out in the way that is most likely to result in the life being preserved of the child when the life of the mother would be lost.
Well, aren't you just talking about taking the baby early? You're not talking. An abortion is actually killing the child, isn't it?
I think the abortion is the ending of a pregnancy early by outside means, I think is the way the definition goes. And so while you call it an abortion, it's really a heroic attempt to save the life of a baby. But based on the definitions that we have, we call it an abortion under that circumstance.
I think what you're saying is it would be a seriously preterm delivery is what you're. I think
yes.
what
yes.
we're trying to get our head around.
Well, I would think that we would want to try to clarify the language there to try to make clear that we're talking about a preterm delivery. That sounds screwy to me.
Well, the way abortion is defined in 319A2, it's bringing the pregnancy to a conclusion, which would include an induced preterm delivery.
It's not exactly, though, our traditional sense of what an abortion is. But
no, I agree with you. I agree with you.
Thank you.
Ms. Abrams.
Thank you, Mr. Chairman. Mr. McKillop, I've got a few initial questions, and then with the Chairman's indulgence, we'll ask some after this. Beginning on line 12, have there been any refereed journals, I've reviewed the information provided by Georgia Right to Life, but can you list any refereed journals that have definitively determined that fetal pain exists at this stage?
I'm glad you asked that question. We actually have a physician here. I don't know about the journal specifically, but we have a physician here to speak to fetal pain and the onset thereof, and the fact that, and I'm not a doctor, obviously, but the fact that a preborn child has all of the functioning parts necessary to experience pain in the way that we think about it at 20 weeks. I've also put some information on the table that you can find at doctorsonfetalpain.com, which refers to a very large number. Those 11 bullet points are all links, and they refer to a very, very large number, and I have them here, of not only testimony before Congress, but also, I believe, peer-reviewed articles demonstrating that fetal pain does exist at 20 weeks.
May I ask, Mr. Chairman, are we allowing outside testimony?
Well, I'm glad you asked the question. I mean, if there's a question that comes from the committee where obviously Mr. McKillop's not a physician and doesn't pretend to be one, that can be answered by someone who's here in assistance of him, that's fine. I just want to make sure, and I think it's proper, that any assertion that would be made by a witness who's supporting, obviously, the author, that there will be an opportunity, for rebuttal afterwards by another witness who can go ahead and say something completely opposite and subject to questions as well.
Will they be allowed to do that today?
Well, I don't know how long we're going to go, but at the very least, if it's not today, it will be at the next meeting. So the answer is yes. I just can't promise you today because I don't know how long we're going to go, because I don't know how many questions we're going to have, and I'd rather err on the side of more questions than less. But the short answer is yes, they'll have the opportunity. If we have time today, sure. If we don't have time today, at the next meeting.
Thank you.
Okay.
So, Mr. McKillop, to clarify what you said.
Let me just say, Mr. McKillop, did you want to have that? Because if the question is there, it needs to get answered.
Yeah,
somehow.
I would like to have him respond to that because he would be much more familiar with any kind of article on fetal pain.
Well,
Okay.
my question was not to articles. My question was to very specific, and with all due respect, Mr. Chairman. The concern that I have is, yes, there are a plethora of articles written on just about any subject because you can find anyone to say what you'd like. The question was whether there have been refereed journals that have definitively concluded this, and if so, if that information can be provided. I don't require testimony at this time. I would just like a list of those refereed journals and the authenticity of those journals. That was my first question. My second question goes to looking at line 31 and looking at line 40. The concern here, and I would like your legal thoughts on this, the standard of care in Georgia is best clinical judgment for most malpractice suits. And you would essentially, for the first time in my mind, and to my knowledge, be stripping doctors of the ability to meet their medically necessary requirements using their best clinical judgment and substituting instead a very political decision. What protections will we be providing for those physicians who may be held subject to civil liability or to civil suit if they fail to meet their medical requirements? And what protection will we provide for them if they are brought before any regulatory board to determine the legitimacy of their actions?
Well, the protections are constitutional. That is, this is a criminal statute, and so the standard would be beyond a reasonable doubt. Now, it would be beyond a reasonable doubt of the standard of best clinical judgment, best clinical judgment, what you said is basically the standard of care of like physicians in similar surrounding circumstances in roughly the same geography as the doctor who is performing it. And I understand that that is a civil standard. At the same time, the entire structure of this code, which already exists, is in the criminal section, and so anything would have to be proven beyond a reasonable doubt. So you would have to have the same criminal standard of proving something beyond a reasonable doubt at any rate. And so there's an overriding, criminal jurisprudence protection. It takes away the subjective value and makes it an objective value, but you still have to prove it all beyond a reasonable doubt.
So my question was not to the criminal; it was to the civil.
Now, I understand, but it's a criminal statute, and I understand I understand what you're saying is there's a civil element to it, but you still have to prove a violation of that civil element beyond a reasonable doubt.
Thank you, but that was my question. So you're saying that there is no circumstance under which a plaintiff, a mother who's forced to carry a child past this time, despite the best clinical judgment of the doctor, because of a criminal statute that he faced. He essentially faces either a criminal violation or a medical determination. You don't believe that there is any circumstance under which a civil suit could be lawfully brought and damages collected on behalf of that mother?
Well, that's an old law school trick question, is can you file a suit for that? And the answer is you can file a suit at any point. Whether or not this has a civil standard or a criminal standard, I believe it has a criminal standard. That is, you have to prove all of the elements of the crime alleged are beyond a reasonable doubt. And so this is not contemplating a civil cause of action. In fact, all of the indication of a civil cause of action has been removed from this.
Well, I understand that it doesn't contemplate it, but does it impact one? And what I hear you saying is you don't believe this will have any predicate impact on a civil cause of action brought against a doctor who violates their best clinical judgment in order to meet a standard that's been set by this law.
I think that in a civil cause of action, the plaintiff would have to demonstrate her case beyond a reasonable doubt.
Okay.
I'm sorry. In a civil cause of action, the plaintiff would have to demonstrate her case by a preponderance, by his or her, by a preponderance of the evidence, which is the civil standard.
Thank you. That's it for now, Mr. Chairman.
Mr. Setzler.
Thank you, Mr. Chairman. I didn't want to wade into this civil conversation. I will tell you, though, as a general, the way this bill is constructed, to the author and to the minority leader, there is considerably more clarity given by the standards you outline in this bill with respect to the basis for the doctor making a determination. As it would stand without any guidance from the legislature, it might be left open. I think you've been very clear in providing some guidance in terms of in their best professional judgment with respect to death or substantial physical impairment and those kinds of things. Was it not your intent to be very clear as to what those conditions could be that would warrant this not being applicable after 20 weeks?
Correct.
Mr. Chairman, I really had just one question as to the current state of the law, and I would take you to. I would ask the author to go to lines 38 through 60. We're in 1612-141. Bottom of page 2.
Say again, Mr. Setzler.
I'm on really on the bottom half of page 2, Mr. Chairman.
Okay.
Looking at the existing language, am I to understand, Representative McKillop, that the current law says that I'm really dealing in lines really 50 through 54. Current law that as long as it's performed in an abortion clinic, current law really allows doctors to openly perform abortions through the second trimester.
Correct.
And then after second trimester, with 2 consulting physicians certifying the abortions necessary. That, again, preserve the life or health meaning any variety of mental conditions within their sole judgment they could deem necessary. That frankly, if there's 3 physicians that concur under the current state of the law, there's really no restriction in terms of when an abortion can be performed in Georgia. Is that the current state of the law?
That's my reading of this law, yes.
Yeah. And that was certainly my understanding, and I would share that with the members of the committee, that even the partial birth abortion law that was passed back in the mid-late 90s has been, because of perhaps the way it was constructed or other reasons, has since been struck down. So the current state of the law in Georgia is through 26 weeks, there is no restriction on abortion. And after 26 weeks, all the way through birth, 39, 40 weeks, as long as 3 doctors concur in their best clinical judgment that it's in the best interests of the, quote, health of the woman, there's really no restrictions. And I don't think, as a matter of practice, folks walking around on the streets in Georgia, I don't think most folks realize third trimester abortions in Georgia are legal, but they are in fact. And is that not one of the purposes of this bill?
Absolutely. We've got a handout, but there are regularly very late-term abortions in Georgia. In fact, the statistics I have show that we're second in the nation after New York and before New Jersey in late-term abortions in the state.
Thank you, Mr. Chairman.
Mr. Ramsey.
Thank you, Mr. Chairman. Could you just, I know there's similar bills have been passed in other states. What's kind of the state of the law? How have courts treated similar bills in other states?
Thank you for the question. What we've got so far is 6 or 7 states have a 20-week limitation. 6 of them based on fetal pain specifically, that is asserting a compelling state interest in preventing a preborn child from experiencing the pain. North Carolina simply instituted a 20-week bright line test for no particular stated reason having to do with fetal pain. So the state of the law is we would be 8th in the nation, and the pro-abortionist lobby has not challenged that in any of the states at this point. And I think the reason for that is that there's a certain belief that based on sort of the constitutional development and evolution of Justice Kennedy's opinions, he was part of the plurality in Casey, which terminated, as we know, the Roe v. Wade trimester system. He has sort of backed away and indicated that the court has on occasion misinterpreted Casey. And he says that there are not only 2 reasons to regulate abortion, as Roe said, but there are any number of compelling state interests that can be used to regulate abortion. And in fact, the Gonzalez case, which terminated, which was a ban on partial birth abortion, regardless of the viability statute, regardless of the viability issue, further muddied that water and basically said there is compelling state interests in regulating abortion and in fact preventing a certain type of abortion prior to the viability standard. And so a big part of my reasoning for bringing this bill is a criticism of the viability standard, which has been articulated in numerous law review articles. That is, Roe v. Wade instituted an issue that said, at viability, we determined that that's the point at which the compelling state interest is strong enough to overcome the right to obtain an abortion in certain circumstances. 2 decades later, Casey versus Planned Parenthood of Southeastern Pennsylvania said, okay, well, we're going to discard the trimester framework, but we're going to keep the viability rule. And we're going to say that the point of viability is sort of the magic line when a state's compelling interest in regulating or prohibiting abortion under certain circumstances overcomes the right to privacy. Now, that was brought into question by a dissent by Justice Kennedy, who was on that plurality opinion in Casey, when he said, look, the court is misinterpreting Casey. There are a lot of different compelling state interests, not just the two that we articulated in Roe. There are things that include protecting the reputation of the medical community, preserving the integrity and ethics of the medical profession, promoting society's respect for unborn life. I believe eliminating pain from a pain-capable living organism, even pre-viability, is a compelling state interest, which would give us the ability to regulate abortion pre-viability without creating an undue burden on a woman's right to obtain an abortion. So I think that there's a good argument for not only a slight extension of the current constitutional jurisprudence, but also the argument that this is and would be an issue of first impression with the court, because we are asserting a new and different compelling state interest, which I believe Justice Kennedy might well decide it's time to do away with the viability rule at any rate. And that's why it hasn't been challenged.
Well, thank you, and thank you for all your thoroughness and preparation in bringing this bill to us.
Thank you.
Mr. Coomer.
Thank you, Mr. Chairman. Representative McKillop, wanted to follow up on the question brought by Representative Abrams about the civil standard of care in criminal cases. It's not novel or uncommon to have criminal statutes which punish something that would otherwise be a civil wrong. Is that a fair statement?
I think that's correct. I think that as an attorney, if I give someone advice, if I simply speak and give someone advice on how to, say, avoid taxes fraudulently, I think I'm subject to prosecution for that. So there are plenty of criminal laws that regulate all sorts of things, and you end up with a criminal standard of beyond a reasonable doubt.
And so it's not novel or unusual to have a civil standard of care used as a measuring stick for criminal liability in Georgia. Is that correct?
I believe that's correct, yes.
Thank you.
Mr. Pack.
Thank you, Mr. Chairman. Representative McKillop, I had a question about some of the definitions in here. Well, first, two questions. Number one, how often is someone prosecuted or a medical doctor prosecuted for performing illegal abortions?
I don't know.
Okay.
I don't know how often prosecutions are brought.
Mm-hmm. And the reason I commented that, if you look at the definition on line 89 of medical emergency, I noticed that you adopted the definition of abortion in line 88 and also in 98. You reference back to the Women's Right to Know Act, Title 31-9A-2. I noticed that there's a slight language change between the definition of medical emergency in the bill versus what's enacted into law under that section as medical emergency.
Yes.
And what I see is that the main difference looks to be that in your bill it says in reasonable medical judgment, and in the other bill, 31-9A-2, medical emergency has the language on the basis of physician's good faith clinical judgment.
Right.
Just thinking back, wouldn't it be easier or more like, even by using the words reasonable medical judgment, wouldn't that make it more difficult to prove that someone's not acting or someone's violating the law? Because there's so much wiggle room for a purpose of proving beyond a reasonable doubt.
Well, actually, I believe what we have tried to do here is insert an objective standard. That is, in reasonable medical judgment of a reasonable medical professional, and that is an item capable of, I think, more clear proof in a criminal court of law. That is the reasonable medical judgment of a reasonable any given reasonable medical professional. If you go with the subjective standard, which is in the Women's Right to Know Act, you talk about the good faith clinical judgment of the physician, him or herself, which is a subject of their own mind only. And so I think with the objective standard, you actually have a much clearer, again, sort of bright line in the medical community, in the medical profession, is this reasonable medical judgment standard as opposed to an individual. And honestly, I think that's why you don't have very many criminal abortion prosecutions, is because that's a loophole. That's I believed it, so it's okay. You can't prove otherwise.
So instead of trying to disprove a subjective standard, as a prosecutor, it'd be easier, obviously, to prove an objective standard.
Well, and I think that makes it yes. Well, number one, yes, that's correct, and I think it makes it clearer across the board.
Ms. Neal.
Thank you, Mr. Chairman. One of my many concerns is I don't see where the bill allots for a woman that's raped by her husband, in reference, I guess, to domestic violence, rapes of an unknown party, nor incest, in their ability to make a decision on not having a child. In those instances, can you elaborate on that?
Yes, thank you for the question. This bill, and that's a very important point, this bill only seeks to prohibit abortions or criminalize abortions at 20 weeks or greater, that is late-term abortions. That's still 20 weeks or 140 days during which the abortions are legal just like they are today. And so in the event, God forbid, of a rape or an incest, there are 140 days of choice.
As a follow-up, is it appropriate, you think, to put a timeline on a decision such as so delicate as that, to give a woman kind of parameters or a guideline as far as a time clock, essentially? Right. And make a decision such as that, because sometimes they refer to their husbands, they refer to their families, things of that nature, and sometimes that decision can be discretionary. Yes, I can appreciate that, and a horrible one and very difficult. Here's my answer to that. It's not me putting a time clock on anyone. It's the Constitution and the jurisprudence of our country. That is, the Supreme Court in Roe said that there is an interest in a life from conception, and that interest, the state's interest in protecting that life, goes up from the point of conception to the point of birth. That is, when it's birth, it's a person. It gets all the full constitutional protections that we all enjoy. At the same time, a woman's right to choose, for whatever reason, starts at the moment of conception. You have the right to choose to have an abortion, and then that line goes down to the point of birth, at which point you obviously it's a baby, it's a person. You have no right at that point. Somewhere those lines cross. The question has always been an arbitrary line-drawing process, and even Justice Blackmun, who was the author of Roe, in the internal memos that they passed around when they were deciding Roe v. Wade, said, we are engaged in an arbitrary line-drawing process. The first two drafts of the Roe opinion, and I have them here, had 12 weeks as the point at which the state's interest in protecting pre-viable life became compelling enough to prevent a woman from having an abortion. It wasn't until the third draft that they moved it from 12 weeks to viability. So the fact that there is a line being drawn past which an abortion is not allowed isn't coming from me. I'm saying we need a bright line test so that everyone knows. But the fact that there is a line is our Constitution. It's the Roe and its progeny. It already exists. And so where those two lines cross is all we're discussing here today, is where do we think as Georgia is a good place for those lines to cross. Viability, which is what the current constitutional jurisprudence has, is a horrible line because it changes based on your geography, it changes based on your sex, on your race. That is, fetuses that are African American are more likely to survive being born early than fetuses that are not. Fetuses that are women are more likely to survive early than fetuses that are men. If you have instant access to a good NICU facility, a neonatal intensive care unit, your baby can survive at 22 or 23 weeks. Whereas if you're in the middle of the desert and they cannot. So the viability standard changes with regard to geography, sex, race, so many different factors, and that is not what a good constitutional jurisprudence line should give us. There should be some solid justification for why viability and why it moves. For instance, in Roe, in 1973, the best medical technology was that you could make a baby live from about 27 or 28 weeks. Since that time, since the last 40 years, our medical technology is now such that 22 and 23-week babies can make it. And so just during these 40 years, the constitutional protection provided by the doctrines established in Roe has moved 7 years with no constitutional action, no judicial action, no legislative action, and that is not a good standard. I want to create a standard that everyone can understand. It's based on medicine. It's based on the development of the child, and it provides a bright line so everyone knows what it is. But it's not me drawing a line. The line already exists. It's just where does the state of Georgia want to put it?
Have two more follow-up? Okay. Well, since it already exists, I guess, in reference to 26 weeks, what's the reasoning for taking 6 additional weeks of decision-making away from women?
Yeah, and I believe, having reviewed the information that I've reviewed and based on the medical evidence that's out there, that a fetus can experience pain. That is, if you stick a fetus with a pin, it reacts. It hurts in all the senses that you and I would hurt if we got stuck with a pin. It has chemical reactions that they're able to measure. Now, there's a doctor here who can testify to this much better than I. In fact, I'd like to bring up Dr. Novembry to testify to answer your question about why 20 weeks.
Well, I prefer you to answer it. But my second question is, moving on from that, do you think it's appropriate for a body such as this, who is majority male, to even be discussing or legislating what a woman should do with her body, being that men are out of touch and don't understand the magnitude of the decision being made at that time?
Well, I guess I would disagree with your premise, first of all, respectfully. I think that everybody on Roe v. Wade was a male at the time, and they're the ones who set this up. I think they got it wrong, and I think that given the fact that we are possessed of so many different professions, so many different sexes, so many different races, we are exactly the kind of legislative body that should come in, debate this issue openly, and make this decision.
Now, if all the men then got it wrong, what makes you think that the men this time are going to get it right?
Because
Ms. Randall.
I'm very serious.
Yeah.
Thank you, Mr. Chairman. I thought that was a good question. Never ceases to amaze me that my 12 years, just about every bill that deals with sensitive nature of a woman's health is authored by a man. Interesting. Anyway, one of many issues that I have with this legislation is that, there are situations where there are families that are anticipating the arrival of a child, and sometimes later than 20 weeks they find out about some extreme abnormalities in this fetus. And if that's beyond 20 weeks, then this bill says that they'll continue to have to carry that child, knowing that it may not have a brain or organs or underdeveloped, that they won't even probably live. And I just think that's terribly unfair. And I know you don't understand, because you don't even have the plumbing to even think about this. But I just think it's terribly unfair to force that on someone already in an emotional state beyond belief. You've been planning, and most people plan children. They get married. They have a timeline. They get married. They want 2.1 children, 2.5 children. The dog, the car, the house. And to get something like that, some kind of news like that, and then we as a body want to bring something that makes them carry this to term, just live with it. And then they got to deal with, everybody wondering, when you're having it, and what's the sex of it. And each day of that questioning, each day of living, knowing that you're going to have to have this child and not really have this child when it's all over. I just think that is cruel and unusual.
Can I gently ask the lady if she has a question?
And I'm getting to my question.
Okay.
So how do you explain it? How do you tell someone to live with that? How can you, in every sense of being a human being, want to have anything to do with forcing someone to live with something like that, an experience that you can't even imagine?
What I would have to say is, first of all, my heart would go out to anyone who's experiencing anything like that. Second of all, I think that any time that you are engaged, as our job requires us to do, in the difficult, emotional, aspect of drawing lines when we're trying to weigh differing interests that the state has in any given set of circumstances. There are going to be hard cases, bad times, tragedies, and I appreciate that, and I think despite your thought that I might not be able to fully comprehend it based on my sex, I believe that I am, and I think that what we have to steel ourselves to do, and that what we have to be mature enough to understand, is that no matter where you put that line, you can always find a really, really bad example and a horrible case that you're not going to be able to legislate so that everything works out right. So I appreciate your question, and we're here to do a job, and I think that this is what I see as the ability to say this is a separate life that is deserving of protection from this state, and that is the point at which that life's deserving of protection overcomes the other issues that are being discussed.
Ms. Benfield.
Thank you.
Number 15?
That would be me.
Okay.
I'm 15.
Okay.
You're on.
Oh, so it is me. Okay. Representative McKillop, are you a physician?
No.
Do you have any formal medical training?
None.
Do you think it's the proper role of this legislative body to dictate the practice of medicine?
I think that based on constitutional jurisprudence, that the Supreme Court has left it to us to articulate compelling state interests, which include specifically, in fact, in Casey, the compelling state interest to protect the reputation of the medical community, preserving the integrity and the ethics of the medical profession, in addition to promoting societal respect for unborn life. So yes, I do think that it is specifically our duty as the legislative branch of government to articulate what we believe to be laws that protect the interests of the state in those different areas.
So you read the Casey decision to say that the legislature should have the authority to dictate the practice of medicine and when doctors should perform medical procedures. Is that your interpretation of the Casey decision?
My interpretation of Casey is that it, in certain respects, reaffirmed Roe, which did find that the state has a compelling interest in protecting potential life of fetuses. In addition, Casey expanded the two interests articulated in Roe, which were promoting the maternal health and protecting the potential life, expanded it specifically to include in the decision at 550 U.S. at 157, protecting the reputation of the medical community, preserving the integrity and ethics of the medical profession, and promoting societal respect for unborn life, in addition to others. Because Casey specifically said at 877, while furthering the interest in potential life or some other valid state interest. So Casey specifically, and this is Justice Kennedy's interpretation of it later, specifically held that there are additional compelling state interests that can be articulated by legislatures which will, as long as they do not prove to be an undue burden on the right to obtain an abortion, allow us to regulate this area. Yes, that is my reading of Casey.
Okay. So your reading is the compelling state interest in protecting the lives includes dictating how specific medical procedures should be done and under what circumstances and what timing. That's your interpretation, correct?
Well, my
because that's what this bill does.
Yeah, and to an extent I think we are allowed because that's what Gonzales did. Gonzales said, even when you're dealing with a pre-viable fetus, you are not allowed to do a partial birth abortion. So Gonzales further blurred the line of viability by saying no matter what the stage of viability is of a fetus, we're not going to allow partial birth abortion, thus holding that the federal government had a compelling state interest in protecting what amounted to, in the Gonzales opinion, the idea that it's basically a murder. And so, yes, I believe that the Supreme Court has left it to states to identify their own compelling state interests, to justify the regulations and make sure that they don't provide undue burdens on the access to abortion that women have, and that is the law of the state of the Roe and its progeny.
Okay.
If you want to say I'm dictating something, that's fine. But the fact is, this is an area that the Supreme Court has said, legislators, legislators, and go do it. This is y'all's job. Do what you think is in your compelling state interest. We'll look at it.
Well, I disagree with that interpretation, but let's get to the specifics of your bill where you talk about 20 weeks in particular. Are you aware that the American Medical Association states that the capacity of functional pain probably does not exist before 29 or 30 weeks. And so your bill flies in the face of the American Medical Association's opinion on when fetuses can experience pain. Are you aware of that?
Yes, I am aware that there are great differences of opinion as to when a fetus can or cannot experience pain. And for my point of view, as I am the author of the bill, I would rather err on the side of making sure that we aren't subjecting a fetus to that pain.
Ms. Abdul Salam.
Thank you, Mr. Chairman. Representative McKillop, a few questions, if you don't mind. My first question would be, why did you bring this bill?
Because I was planning to go and sign on to Alan Peake's fetal pain bill last year. I started looking into it and saw that there were some differences of opinion about whether or not it was actually language that would accomplish the goal. I began doing research on that and reaching out to various legal experts on the matter and redrafted some language, got together with Alan on it, and rather than signing on to his bill, we decided to bring it as a new bill to clearly set forth a bright line test for Georgia, because Georgia is second at this point in the nation in late-term abortions.
So no women came to you and asked you to carry this bill? No mothers?
My wife did.
Thank you. When you talk about, you and Representative Setzler had some conversation about third trimester abortions, late-term abortions, and the reference to, I believe, current law was that there had to be consultation with at least 3 physicians. I'm sorry, after 26 weeks. I guess my question would be, who would pay those 3 physicians?
We've eliminated the requirement of having extra physicians to be consulted.
Okay, so that is no longer the requirement.
That is well, not in our suggested language.
In suggested language. And to the issue of fetal pain, which I would agree that any pain is terrible. I guess where I have real question, though, is that sometimes mothers make a decision on not bringing a child into the world based on pain that will be greater later on. Hunger pain when they can't feed a child. Emotional pain when they can't take care of a child. The pain of neglect and abuse, the pain of not being able to provide for that child, the pain of murder, where we're seeing children every day being murdered and tossed away like garbage. I would argue and ask you to consider that it's sometimes more humane to let a woman decide, what's best for her child, in regards to whether or not she brings them into the world. Because whatever amount of pain is felt by the fetus, the mother's going to feel that pain too. I also would ask you to consider, having been a rape survivor, sometimes you don't know you're pregnant at 20 weeks. Consider the fact that women, thousands of women in this country and elsewhere, are full-term and delivering babies before they know they're pregnant. It is not fair to set a time limit on what they can and cannot do with their bodies. It is a fact of nature and biology that you don't always know by a certain time. And if there is a way that you can give a looking glass and a magic ball, then everybody would schedule. So I would ask you to please, in your legislation, take out the time limit. If nothing else, take out the artificial time limits. You can't regulate that. Thank you, Mr. Chairman.
Thank you, Representative.
Yes, 20. Oh, sorry.
22. Thank you, Representative. Is it not true the same women who talk about it's their bodies are the same ones who want to mandate nutritional, healthy foods on our children?
If the lady so states.
Thank you.
Let me ask you a question. You made a statement, and there are a couple of others that have mentioned as well about the late-term abortions and where Georgia stacks up from a number standpoint or a volume standpoint. I just, when I heard that, I found that pretty startling, and it's not something that I knew beforehand. What I'm interested in is, and if you say it, I believe it. I'm sure it came from a credible source. But what are we talking about in terms? I'm curious about what are we talking about in terms of numbers. In other words, I think you said we're number 2 or 3 in late-term abortions. I assume that's defined as the last trimester. What is that in real numbers as opposed to relative to other states?
Let's see. I had a handout on that.
And let me make sure I understand the current state of the law as well, and that is that in the last trimester, it's if there's an issue regarding the health of the mother, and if 3 physicians have signed off on it. Is that a correct statement? Okay. So I'm told that's correct, so I believe it's correct.
The late-term abortion, the statistic that we're third is from the Guttmacher Institute, and that's online. They did a paper on it in January of 2011. The information from the Georgia Department of Community Health shows that there were in Georgia in 2009, which is the most recent date that we have information available, 1,281 abortions past 20 weeks.
Past 20 weeks.
Correct.
You said earlier about the late term. Is there a volume number there about just actual numbers in terms of the late term abortions?
Well, the numbers are. Is this the handout you're looking at? It's by week, so depending on what you would like to determine is late term.
I'm saying that out loud as the last trimester. Is that an accurate statement?
The trimester framework was abandoned in Casey. So, when you start talking about viability, pre-viability, post-viability,
okay,
it's a moving target. If you say late term is post-viability, we're down to around 23 weeks.
And from what I'm seeing right here from DCH, it's actually in the single digits. Is that correct?
If you start at 23 weeks...
I mean, in the 30s.
If you start in the 30s, it's 2 or 3 a week, 5 or 8 a week, okay, from 30 on.
I was just trying to get a handle of just what we're talking about, not that... I mean, the concept obviously is the same, but I just found that to be a startling statistic. I just wanted to get a little more information behind it. Mr. Vice Chair.
Thank you, Mr. Chairman. Representative McKillop, I wanted to go back to the question that the minority leader asked you about the standard of care and see if we couldn't clarify that just a little bit. If I may offer a couple of things. Her concern was based on the potential civil liability for doctors, potential disciplinary action, things of this nature. Am I not correct that with the passage of this statute, which has criminal implications and criminalizes certain behavior, that would in fact impact what the civil standard of care is? That would help to shape what the doctor's standard of care is?
I think that as a practical matter, that's correct.
Could you lean forward and speak into the microphone?
I'm sorry. I think as a practical matter, that is correct.
Okay. And isn't it also true that if you have a criminal statute and that prohibits a certain type of behavior and it's designed to guard against a certain type of a risk, that if a doctor were to do something in violation of that statute, that as a practical matter, it's negligence per se?
Violation of a criminal statute is, my understanding, negligence per se.
Under tort law.
Yes.
And so that would seem to support the idea that, I don't know, we're back and forth here, but that would seem to support the idea that this law would help to fashion the civil standard of care, and ultimately that no doctor is going to be held liable civilly or disciplinarily or anything else for complying with the law if this passes.
I agree with that.
Thank you.
That's a very clear statement of the question. Thank you.
Thank you.
Ms. Abrams.
Thank you, Mr. Chairman. If I may, because
Sure.
I appreciate the aggressive responses to my question from members of the body. Just to be clear, yes, it could shape as a practical matter, but so could the success of civil lawsuits. And so I think it's important for us to be very clear that nothing in this law would preclude the successful prosecution by an aggressive civil practitioner of this lawsuit. And malpractice insurance rates are not based purely on the legal standard. They're also based on the success of those suits or how often those suits are brought. And so I think it's important for those who are so opposed to the increasingly litigious society that we have, that we may be creating a standard that leads to a number of new lawsuits, which could also raise the cost of malpractice insurance in the state, because you need one really good suit that makes it through and things will change. So I appreciate everyone trying to respond to my question, but I really did want just his position. But to Mr. McKillop, are you familiar with the definition of hypocrisy?
Why don't you tell me?
I'm asking.
I mean, let's make sure we're constructive.
This is
opposed to personal.
I'm not being personal at all.
Okay.
Because earlier in your statement, you stated that you seek to, and I'm quoting as I tried to take it down as much as possible, eliminating pain from a pain-capable child is a compelling state interest. Is that not what you said earlier today?
Yes.
Is it not also true that anatomy scans are not performed on children, on fetuses? Fetal anatomy scans aren't typically performed until 18 to 20 weeks.
I'm not a doctor. I don't know, but I have a doctor here if you'd like to ask those questions.
Well, I will state that as it is common knowledge that is so, and feel free to review that. Among those fetal anomalies are several brain injuries which cause fetal pain. And that fetal pain tends to be caused by having open brain cavities, having encephalitis, versions of encephalitis. You have a number of brain hemisphere anomalies that aren't discovered until that 20th week. Yet under the provisions of this bill, a mother who is made aware of this at the 20th week would be precluded by that very same scan from taking the action necessary to stop that fetal pain. So a child who has absolutely no likelihood of success outside the womb would be forced to be carried to term in fetal pain for the duration of that term, and could be brought to term, but kept in fetal pain the entire time, not subjective fetal pain, but known fetal pain caused by these brain injuries and these fetal anomalies. And at that time, upon birth, would likely die shortly thereafter. Do you see anything hypocritical about creating a law that prohibits fetal pain and also creates fetal pain at the same time?
In my discussions with various members of the profession, I have been convinced that all of the testing and everything else can determine all of the fetal abnormalities save one by 18 weeks, the one being any kind of fetal heart defects, which can't be determined sometimes for years and years, even after birth. So what I would say is, would I like to make a law that would eliminate all fetal pain? Yes, absolutely. Can I do that? No, I cannot. Can I suggest a law that I think eliminates a great deal of fetal pain? Yes, I can. And in the balance of things, I think mine does a better job of it.
Would you be amenable, given that the window for those fetal scans is actually 18 to 20 weeks, given the probable gestational age and given the availability of these scans, would you be amenable to extending the time period to 22 to 24 weeks, which would provide a clear window, a safe harbor for parents who will not have information until after the 20th week and will need some time to digest that information and make decisions about the health and viability of the fetus that the mother may be carrying at the time?
Of course, it'll be up to the committee to make any motions for amendments. I would oppose same. I drafted the bill in a way that I'm comfortable with. Of course, I always respect the will of the committee.
Thank you.
Mr. Setzler.
Thank you, Mr. Chairman. I wanted to ask the author his opinion on some of the perspectives that were shared in some of the earlier questions. We've been discussing a lot about, and I've heard a lot of questions of you to the author about regulation of doctors. Is it not the purpose of the legislature to protect people from crimes?
That's one of our purposes, yes.
Isn't it true that this legislature's acted on protecting people from everything from sex trafficking to murder to a whole variety of crimes? And that's what this committee's charged with within the House?
Yes.
Isn't it true that a child in utero, arguably much earlier, I would certainly argue much earlier, but I would argue undeniably 20 weeks and beyond, is a living, distinct and whole human being that has its own blood type. It's distinct from its mother. All it needs to die of old age as an elderly person is a safe place to live and nutrition?
That's correct.
Okay. We talk about compelling state interest, and that's certainly what's in play here, but I think I would just remind people that if there were a child that were born that were 2 weeks old, that were 2 months old, the same arguments can be made, isn't it true, that a child that has a bleak future, doesn't have socioeconomic opportunities or educational opportunities or even a loving home. Arguments are made by some people, particularly in academia, that would say it's cruel and unusual to bring this child up and let them live to adulthood. And one can make the argument that a child that's 30 weeks along in gestational age that could be let the woman to decide what's best for her child. Isn't it true that that same argument can be made for a child that's 20 weeks, 30 weeks, or that's 2 weeks old out of the womb?
Yes.
I would suggest to members of the committee to consider, and I want to just get the author's opinion on this, to suggest that it's best for a child that they be pulled apart in a medical procedure. I mean, folks, let's face it. And discarded as medical waste. To suggest that's in the best interest of the child is, I think, ushers us into an era where we would suggest a child that's 2 weeks old could have the same thing done to them if they, by happenstance, were delivered early. Mom didn't expect to deliver at 32 weeks or at 28 weeks. And oops, didn't mean to have the child. I had my abortion scheduled for next week, but the child was delivered. The child's alive now. I mean, there's really no distinction, I would argue, and I want to get the author's opinion, between a child that's born at 28 or 36 weeks as a child that's inside their mother safely at 28 or 36 weeks.
Right, and I'm approaching this, and I can appreciate the emotion involved and the sometimes barbaric procedures that we're talking about. Gruesome is how the Supreme Court has described it. What we're doing is we are engaged in the line drawing process, and we have already been told by the Supreme Court of the United States that there is an interest in protecting life before the child is born. So we're already in, once he or she is born, that's one thing. We're now moving that line backward, and the question is, how far backward do you move it, and can you articulate a compelling state interest that overcomes the right to abortion? And so I agree with you. We are treating that life as a living being at some point. They do it at viability. Where does that line occur?
Do you believe that it's within the medical profession that it's money well spent having neonatal ICU units that if children are delivered at 24 weeks, they can be kept alive and allowed to grow? Do you believe that's a viable investment of our dollars?
I do.
Do you see an inconsistency if we're investing our medical dollars in going to great lengths to protect a child that's 24 weeks that was born accidentally but that's in our world, and the notion that a procedure, a person frankly for hire, a physician could be paid $3,000 or $4,000 to take that same child that across the street might be being preserved in a neonatal ICU, that one could pay to have that another child that may be unwanted literally pulled apart piece by piece?
Yeah, I think that's tragic.
And Mr. Chairman, I'll close by saying this. I'm not trying to be fantastic but this is a sober body. We're adults. The procedures we're talking about are doctors using instrumentation to pull children apart limb from limb and dispose of them with medical waste. That's the procedure we're talking about. I mean, we can cover over it by talking about standards of care and compelling state interest, but the fact of what we're talking about is licensed physicians taking medical instruments and pulling children apart limb from limb inside of their mothers and disposing of them with medical waste. And the question is, if we're protecting them with millions of dollars in neonatal ICU units, why are the unfortunate ones that perhaps are not desired or the products of, an unplanned pregnancy, why are they treated so dramatically different?
Mr. Coomer.
Thank you, Mr. Chairman. I just wanted to follow on Representative Randall's earlier example of a child who would, in her example, clearly be stillborn, and also Representative Abrams touched on the same issue. First of all, let me say I would thank Representative Abrams for making clear to us that fetal pain is, in fact, not a myth. I mean, this is something that seems to be universally accepted, that fetal pain is a real issue, a real problem you're trying to deal with. So thank you to her for acknowledging that, and thank you to you for bringing this bill. But to make this very clear, we are considering a criminal law bill here today, correct?
Correct.
And in fact, the bill is such that it would create a felony, or at least modify a felony criminal statute in Georgia, correct?
Yes, it amends what is already a 1 to 10 year felony in Georgia.
And in every inch of the state of Georgia, a felony prosecution occurs when an elected DA decides in her discretion to take a case for indictment to a grand jury, correct?
That's my understanding.
Okay. And then the grand jury of citizens votes to send that case to trial or not. And then that trial proceeds in front of a judge or a jury who has to convict the person beyond a reasonable doubt or find them not guilty, correct?
Yes.
So we have lots of safeguards in our criminal justice system in Georgia, correct?
Yes.
So my question to you is, how likely is it, in your opinion, that an elected district attorney is going to prosecute a doctor in his community under the circumstances described by Representative Randall and Representative Abrams of violating this criminal statute, exercising their discretion to actually prosecute that case, where a stillborn child is allowed to be terminated early?
Not ever having prosecuted cases, I would have to defer to the judgment of any given DA or assistant DA who might bring that case. But I certainly appreciate the point that you're making, which is well taken.
Well, let me say I have prosecuted cases, as other members of this committee have, and I can tell you I also happen to have run for office in my community, and I don't think I would be very comfortable running for office in my community if I had prosecuted a case like that. And even if the DA brings the case, we still have the grand jury and the jury or the judge at the trial who are safeguards against any kind of abusive prosecution, correct?
That's correct.
Okay. Thank you.
Mr. Pack. I'm sorry, Ms. Neal.
Thank you. Actually, I have two in an example. Okay. Well, the first question, Representative Setzer mentioned it will be money well spent in reference to, I guess, caring for the child in the NIC unit. But where in the bill does it explicitly state that funds will be allocated for that, and will the state bear the burden of the cost of the abortions that are forced upon the women?
We're not allocating any money. This is not a budget bill. This is a criminal statute.
Okay. Along with that, just to give you an example, when going through case studies through my various homicide investigation courses, we had to examine a mentally unstable woman who had a child. She carried the child full term, had the baby, but she ended up murdering the child. It was a rather graphic way she murdered the child, but either way, where does the bill state that women that are mentally incapable or unstable, does this bill force mentally unstable women who doctors may deem unfit to carry, even to full term, regardless if they're raped or not, where does it allocate for them if they are allowed to have an abortion for fear of things such as the example I just gave you, knowing that they wouldn't be able to properly take care of the child? Would that, in fact, forcing the unstable woman to carry the child a full term, possibly deliver, in that case, if they do find that they are mentally unstable, be put into de facto custody until they're either adopted or turn 18? Is that also money well spent?
I'm going to have to ask you to repeat the question. I'm not exactly following.
I'm just asking. This is kind of two-part. Well, one, where's the bill address mentally unstable women carrying babies?
It does not.
Okay, and then the
Not
second
specifically.
part.
Not specifically.
Okay, and then the second half is in reference to the money well spent reference that was made earlier. Do you feel that after forcing a woman in that mental state to carry the baby, the state incurring that cost all the way up until a certain age, is that some money well spent too when the child could have been aborted earlier to avoid any of the issues like I stated as far as defects and that whole process and years of state custody?
Well, I think first off, this is a late term abortion prohibition. So I don't know how exactly the mental instability of the woman plays into your example, but we're not allocating any funds for anything. I hope that covers it. This is not a budget appropriation for any given set of circumstances. This is a criminal statute to prevent abortion past 20 weeks.
Well, who would pay for it?
And so when the person, whoever would normally pay for it, it doesn't have to do with who's paying for what or who's paying for a baby or anything else. Hopefully the mom and dad would pay for it. Raise the child.
Okay. Thank you.
Mr. Pack, do I see your light there? All right.
Thank you, Mr. Chairman. Representative McKillop, I agree with you. I think one of the state's compelling interests is to protect life. Obviously, that's in the Declaration of Independence. It's founded upon it's in our principles. Apart from I guess some of the religious implications of that. The question that I have is related to the medical profession. One of the issues that I have about the 20-week time period is what I don't want something to happen. If someone is approaching week 19 and week 20, I don't want them to choose to have an abortion because of that deadline coming about. The question that I have for you is, with respect to a doctor when they decide to perform the procedure during that time, what are some of the guidelines that are required to go through before performing an abortion? I mean, are there standards that are articulated that they're supposed to go through, supposed to be medically necessary, or just no questions asked, kind of go forward? And frankly, admittedly, I don't have the plumbing. I mean, I understand. I'm asking from a perspective, trying to be objective, because I don't want unintended consequences of increased abortions at 19.
Right. Well, the Woman's Right. I mean, are you referring to the Woman's Right to Know Act, and that is what different procedures have to go through with the woman prior to the procedure being conducted? That's at 319A2 et sec. So that's all already in statutory law as far as what that is. With regard to any other regulations that the state puts on here, it's been pretty clearly articulated from the Supreme Court that what we're dealing with is you are allowed to control the environment to make sure that you protect the health of the mother. That is, it needs to be a licensed hospital, ambulatory surgical center, health facility licensed as an abortion facility, and you have to be a doctor. So those are really, other than that, the reporting requirements and the Woman's Right to Know Act, that is where we're at in Georgia on regulating, and that is a fair amount of that language actually comes from the constitutional jurisprudence on it. And we don't add anything to that here. We're not saying that you have to go through anything other than determining the gestational age of the baby.
I understand that. As a matter of best practices in the medical profession, I mean, have they adopted some guidelines, or anyone that goes through what they should do, what kind of discussion they should have, apart from what's articulated in the statute you refer to?
I'm not a doctor again, but I don't know what they do or do not do. I guess it depends on the particular physician, what his or her practices are with regard to informed consent and understanding what's going on and all the different options. But I'm not a doctor.
Ms. Abdul Salam.
Thank you, Mr. Chairman. Representative McKillop, going back again to the 20 weeks time limit, I think that, let me ask you, are you aware that this time limit also sets discriminatory barriers for poor women due to the fact that the cost is always prohibitive, and it takes longer sometimes for poor women to come up with the money for an abortion. I asked, are you aware?
I would simply say that it treats all women equally, as the law should.
That's not equal. I asked, are you aware that it creates a discriminatory barrier for poor women due to the cost?
Given that it's one line and not another line, I understand that that is your position, yes.
I didn't ask if you understood it was my position. Okay. On page 4, at line 115, you also set out additional reporting requirements. And it seems to be a duplicative effort for what we already require in the woman's right to know. Is that something that can be eliminated, because basically the Woman's Right to Know Act requires mostly the same reporting information?
It's nearly the same, but we did add the determination of probable gestational age and a few other items to it. But I think it could all be accomplished on the same form, yes.
So what would require 2 reports?
I think it would require 1 report with a couple more lines on it.
Okay, thank you.
Let me ask you a question about, and you just touched on it in your previous exchange on the probable gestational age. I'm looking at line 99, and really it relates back to your comments earlier about deciding where the line is, and that is the proper role of the legislature on many issues, including this one. But I think you'd agree that if we're going to decide where the line is, we need to at least have as clear a definition of what the line is and where it is, so that there's predictability for everyone involved. And I just want to work through it, talk through it on this probable gestational age. And I'm looking at, as it's, I know that's that's sort of the pivot point in the calculation of the line, right?
Correct.
And so on line 51, it's in accordance with 31-9B-2, and I'm flipped over there to line 99, means what will in reasonable medical judgment and reasonable probability be the post-fertilization age of the unborn child at the time the abortion is planned to be performed or induced, as dated from the time of fertilization of the human ovum. I'm worried about somewhat of a lack of definition, understanding that this is by definition inexact, and I'm concerned about getting the line as clear as it can be from a definitional standpoint. That regardless of what we're talking about in the law, you want clarity.
Right. My understanding.
So if you can speak to that.
Well, my understanding is from talking to the experts that I have that a good ultrasonographer can, certainly in the first trimester, determine the date of fertilization to within 2 or 3 or 4 days.
And I understand that, and just for members of the committee, when we have the doctors come up in the next meeting,
right. And
there'll be a debate there, just as there's been a debate here, but I just wanted to get your
This goes directly to
it.
beyond a reasonable doubt. That is, if someone comes in and says it was 20 weeks and 3 days, and you have sonographers come in and say you can't determine it to within 6 days, then obviously you have not proven a case beyond a reasonable doubt. We understand that there is some inexactitude in this because the point of fertilization occurs behind a curtain. You don't get to see it. You don't know exactly when it was in the great majority of circumstances. And so there is, that's why we have an reasonable medical judgment with reasonable probability. That is, you go and you do an ultrasound and measure everything and base it on, the development of the fetus and then work backward.
Okay. My sense is that we'll go ahead and we'll probably ask for an expanded conversation on that with medical professionals at our next meeting. It just begs for that kind of debate.
Sure.
Just to so we can get our heads around that. Ms. Neal, did you have something else? All right.
Thank you. It's more so a statement, just something to consider for the author. Just in general, with all respect to women, regardless of what side of the aisle anybody sits on or how they feel about the issue, if there's already something in place that already gives a timeline, and like we've already discussed in various instances that this is a sensitive issue, I just don't think it's fair to take even more time away from women, especially if it's a matter of 6 weeks. But along with that, I mean, we throw terms around here loosely, and I'm not offended by it, but, things such as plumbing and stuff like that, and it just gets to a point where it sounds like the women's bodies in this discussion are just shells, empty shells, just making it where women's bodies are just used in this debate for delivery, and that's it. What they think, what they want, nothing else matters. And granted, all of us are concerned, of course, about any child that's born or not born, but we can't lose the conversation about the woman and what she wants. She's a human too, and we can't forget that.
Right.
And we have to preserve that life and what that life wants as well, just as much as the life that's being created inside of her. So I do want you to keep that in mind.
I fully comprehend that, and I respect that. And what I'm seeking to do with this legislation is balance the concern and interest that you're articulating, and also looking at it from the point of view of the fetus, and saying where in the balance should we as a state say that those interests are equal, and then that the fetus's interests exceed. And that is the line drawing that the Supreme Court has said we must do, or we should do as a legislative body. And so I fully respect it, and that's exactly what we're talking about is those two competing state interests and where we draw the line.
Okay. Thank you.
Thank you.
Any further questions from members of the committee? Seeing none, I think it was an excellent discussion, an excellent dialogue. So I think we've done well today. I think what we're going to do is, we have half an hour left on the room. I think it would be wise just to go ahead, and this is a good break point since there are no further questions from members. What we will do is advertise in a timely manner, send out the notice for the next meeting, which we will determine by the end of the day tomorrow.
Mr. Chairman, I feel like with the 4 or 5 questions that we had on fetal pain and my constant request to have someone assist me with regard to those answers, if I may ask, so because I understand that there's going to be testimony on the other side with regard to fetal pain. I have a doctor here with me this morning that could speak, or this afternoon, that could speak very briefly to the issue that was asked of me, and then when I said I needed some help on the answer, quickly moved on, and now that representative has left.
Yeah.
But if they're going to ask the question, then I should be allowed to present someone to give the answer.
I don't have any problem with someone coming up to go ahead and give that answer, because the question was asked, and just for members' interest, there will be ample time for any rebuttal of that statement, and depending on how long this individual takes right now, allow time for questions. We have half an hour. We're not under any duty to leave just because there are no further questions, but we will. We might as well go ahead and use the time.
Thank you.
But again, understanding that there'll be proper time for rebuttal when we have the next meeting. Yes, ma'am. Sure.
Have our meetings, you are very fair when it comes to both sides, and in this instance, I understand Mr. McKillop's position, but at the same time, it is his responsibility to present the bill that he brought to us. So, in all fairness to both sides, I would prefer that we wait on all testimony. Just in all fairness, just to being equal. Like I said, I know that you always are, and in this event as well. Just because the representative left, we're still within the same time frame and parameters. So, I would still submit that would still apply at this time. So just in all fairness, because there are going to be other sides to the same questions that we asked that won't be able to speak either, just because they're not on Mr. McKillop's side.
Well, I mean, but again, I just want to make sure it's clear. This isn't a one-time shot. It's not as if you don't testify today, you lose. No, that's not what we're talking about. The question was asked, and there is someone who can answer the question. My regret, honestly, is that the representative who asked the question isn't here to answer it. That's my greater regret, and it's not anything regarding her. She has other things to do.
Well, should we wait till she gets
other meetings?
To be able to answer the question?
I would like that to occur. Let's do this. We have the time. If there is, what I will do is, if at the next meeting there is, I mean, Representative Neal, you're here, Representative Randall, you're here. My sense is that you may take a parallel position with the minority leader on the issue. If you have questions of this particular individual, that's fine. If not, I think there's certainly ample time for the minority leader to go ahead and ask whatever questions she wants at the next meeting, or if she comes back, you know, she's right now. But, you know, if an individual's here to answer a question that was asked that the author doesn't have the answer to, you know, more information is better than less, understanding, again, that there will be ample time for rebuttal by either medical professionals and, frankly, by members if they want to go ahead and take that on as well. So, Ms. Randall, you have something?
I agree with that, Mr. Chairman, but the only thing is that I'm certain that because there was not, that we were told that there would be no testimony, that there may have been another side to how that question can be answered, and they would have been here had they known they would have the opportunity. So I think it's kind of unfair to allow that at this time, and with the minority leader not being here, I can't speak for her, but I just think, you know, we could have had two different opinions had we known that we would have been allowed to have that. And I think
and that's the difference, Representative Randall. I just don't consider that to be public testimony, and I'm not going to split hairs about what is public testimony, what's not. A question was asked. Representative McKillop is not a doctor, doesn't pretend to be one or play one on TV, and so he wants to go ahead and have an informative answer back. That is subject to rebuttal. It is rare that the chair exercises any sort of discretion whatsoever and almost runs this committee like it's a courtroom, but in order to be egregiously fair. But I think at this point, since we have a few minutes, let's hear from somebody. And if, you know, and members are free to go ahead and question that individual as freely as they want up until the time that we have to go. You know, and again, there'll be ample opportunity at the next meeting. This is not a one-time shot. So.
Where would you like him to be?
Up there with you, I guess. And I would like to, in respect to other individuals' questions, I would like the individual who's going to speak right now to, number one, identify himself, and if we really do need, in deference to Ms. Neal's point and Ms. Randall's point, and I'm sorry that she's leaving in order to not appreciate this, hopefully, to really confine comments to the question that's addressed, or the question that was asked.
My recollection of the question, that was actually a number of questions, but I'll try and summarize them all into one, which was basically, what makes you think that fetal pain occurs at 20 weeks, and don't you know that the AMA says it's 26 or 9 or whatever she said? And so, since I have a doctor here who, and I'll just let him introduce himself and give you his background on fetal pain.
And sir, if you could obviously let us know who you are, what you do for a living, what your, I think what your formal background is, your training, what you do on a day-to-day basis, just so we can know who we're hearing from and your experience.
Good afternoon. My name is Dr. Emilio Novembre. I'm an anesthesiologist. I specialize in pain management. I have a Bachelor of Science in Chemistry. I have been specialty fellowship trained in obstetric anesthesia. This includes training in perinatology and also neonatal intensive care. I trained at the University of Medicine and Dentistry in New Jersey. I'm board certified in anesthesiology with a certificate of added qualifications in pain management. Since graduating medical school, I've personally anesthetized over 15,000 patients, including neonates, and intending to and providing either general, epidural, or spinal analgesia for over 5,000 obstetric deliveries. I've also treated over 10,000 chronic pain patients. I've also served in the United States Army Reserve in the Medical Corps for almost 10 years, honorable discharge as a major. I practice pain management and anesthesia on a daily basis, also addiction medicine. I'm also board certified in addiction medicine. I'm also a board qualified toxicological chemist. I also lecture in anesthesiology and addiction medicine. I've attended hundreds of hours of lectures in pain. I have thousands of hours of clinical experience in treating pain. I could go ahead and answer some of the questions I recall.
I think that if we could do that, I just in the interest of time and to consolidate.
One of the first questions was there any refereed or peer-reviewed journals? One of the main works cited is the study that shows that there is a plasma cortisol increase with fetuses that have been subject to pain at 20 weeks. The journal is The Lancet, which is the most recognized medical journal in the world. It's been around for hundreds of years. It's a weekly peer-reviewed journal that originally came out of Great Britain, so it's probably the oldest. It's right up there with the New England Journal of Medicine. In terms of the AMA's position, you may well be aware that pain management is one of the largest problems in the country because there's so many patients overdosing on narcotics. And the reasons this is because physicians receive absolutely no training in pain management in medical school. The average physician receives no training in pain management in residency. They may gain clinical experience just by the upper resident telling them, give this patient some Demerol morphine post-op pain, but actual lecture hours, none.
I apologize for interrupting. Could I ask you if we could focus narrowly on fetal pain, and I appreciate your making the effort to be here, but really go to the issue of the heart of the questions that were asked earlier about fetal pain, what is experienced and when, and draw upon, I assume you'll draw upon your experience to illustrate that.
The fetus begins to develop neurosensory pathways to perceive pain as early as 8 to 10 weeks. The nervous system brings in information through the peripheral nervous system, the arms, the legs, the outside body, through the spinal cord. This is intact around 12 weeks, and then it brings information through the thalamus, which is the main pain receptor organ in the body, as early as 16 weeks. At 16 weeks, there's development of the subcortical plate, which is a transitional anatomical organ that provides the relay of information from the thalamus to the cortex. By 20 weeks, the fetus is able to feel and sense and respond to pain and also be aware. The fetus actually not only feels the pain, but actually feels more pain than a newborn baby or an adult. The reason for this is our nervous systems not only develop tracts that bring sensory into our body, to the awareness, to our cortex, but we also develop, we call them ascending pathways because they come up the spinal cord. We also develop descending pathways. And the descending pathways actually inhibit the pain response. We all know when we feel pain, it's horrible in the beginning, and then it starts to fade. That's because we send the signal that comes down the descending spinal thalamic tract and releases, the most common is endorphins. We're all aware of what an endorphin is, which is our body's own production of morphine-like substances. Endo means inside, orphans, endorphins. The fetus actually has not developed these pathways, so that the fetus not only feels the pain, but it's magnified. When the fetus at 20 weeks is being dismembered or sometimes aborted using hypertonic saline, which is like 3% normal saline, it's actually being burned to death chemically. The fetus not only feels it, but it's actually more excruciating than any pain that anyone ever feels when they have pain. And this occurs maybe even as early as 16 or 18 weeks, depending on the fetus, but definitely by 20 weeks. And the research performed has shown that there's a stress response at 20 weeks. When we do perform surgery in utero to correct maybe a valvular defect, the fetus is given some analgesics, usually subcutaneously, fentanyl, to attend to the the discomfort the fetus will be subjected to if there's an incision made on the fetus.
Questions? Ms. Neal.
And I mean no offense, and I'm just a tad bit concerned. I guess this question goes towards the chair. I don't know, when I look at the reviews of this doctor online, vitals.com, it gets a 2.4, 3 of 5 out of healthgrades.com, lifescript.com gives them a 1, avo.com gives them a 6.7 out of 10. When it comes to accurate diagnosis on vitals.com, 2.2 out of 4. I'm just concerned about, I guess, the definition of expert in this case, and I don't feel confident in, I guess, the testimony.
And that's the lady's privilege. I mean, we have people testify all the time, and we're going to make individual judgments about what they say and their backgrounds and so forth. I mean, this, like any other situation, I just would caution anyone as to what they read on the internet. Mr. Setzler.
Thank you for coming today, Doctor. I know you don't make a living by talking to the legislature, so I know it's a sacrifice to be here. I just remind the members of our committee that there may be a portion of this bill that's relevant with respect to fetal pain. I think it's that the author, it was by his testimony somewhere in his calculation, but with or without, I mean, we could be all over the spectrum on the fetal pain question, but I take us back to the conversation we had before, and I'll hesitate to do it with the level of clarity perhaps I referred to in the past, but the reality still is there could be a range of fetal pain at 20 weeks, 22 weeks, 30 weeks, but the reality is the same babies we protect and spend millions to take care of in our neonatal ICU units are systematically being destroyed by physicians for hire and legal procedure in the state, and it's the gentleman's position that it ought not be legal. And it is clearly the job of the legislature to determine what is a crime and what's legal. And I think I would caution our committee to spend too much time on the trail. I think it's relevant to this conversation, but I don't think it's central to the conversation of relative amounts of pain versus the reality of what we're dealing with. So again, it's relevant to the author, and I just wanted to remind the committee and ask the author to comment on, is it not true that that although pain's part of the conversation, it's not the central question here.
No, and that's correct. And like I said at the beginning, 20 weeks is a bright line, regardless of the reason or compelling state interest or not. For instance, North Carolina just said 20 weeks is it. We find that there's an interest in protecting life at that point, for no other reason than that's the point that they chose. So,
thank you.
Let me follow up on that. You mean, and this inevitably comes up in nearly any legislation that we discuss, certainly in more highly charged pieces like this. Can you give us and perhaps a handout later would be helpful as to what other states, how many other states have adopted something of this type? What is the line? We keep on talking about the line. And
6 states have adopted, and I can call them out for you now. 6 states have adopted it based on fetal pain. North Carolina has adopted 20 weeks not based on fetal pain. The 6 states are Alabama, Idaho, Indiana, Kansas, Nebraska, North Carolina, and Oklahoma.
Just to make sure I've got the differentiation, when you say a state has adopted, and for clarity and for purposes of the record, when a state has adopted the bill with fetal pain and then without fetal pain, if you could just define that.
Well, I think that what the chart I have means is that they are referring to those states as having adopted a 20-week standard and citing, therefore, the compelling state interest that they want to prevent pain-capable fetuses from experiencing that.
Okay. And then some states have adopted without reference to the pain issue?
Just North Carolina.
So there was a bright line of 20 weeks without reference to any other consideration that would have that supposedly supports the 20 weeks.
Without the pain aspect of it. I'm not sure. I haven't read the North Carolina statute, so
Okay.
I don't know what they cite as their compelling state interest, but I'm sure they cite something. It could well simply be the protection of life.
But it was just, frankly, a bright line of 20 weeks without any reference to any other.
Correct.
Any other? Okay. I just want to make sure that's clear. Okay. Any further questions? Seeing none. Again, just to make sure we're clear on next steps, we'll have another meeting. Of course, Monday's a holiday, so we're back in after tomorrow on Tuesday. We'll endeavor to go ahead and get a notice out. We'll endeavor to get a notice out tomorrow. I think the interest will be for the next meeting. I think it would be constructive and helpful for the committee and members on both sides to hear from the medical community. We will divide the time as we do evenly. How much physical time that will be honestly will depend on what room we can get, what day, and for how long. And then we'll have that meeting. Of course, the individuals who will testify. I don't think it'll be constructive for us to have 10 doctors coming up for 2 minutes each to answer questions for another 3 minutes and sit down. This is the type of issue, and I think this meeting, and for those who have not been to one of these meetings before, we dig right down into it, and it's a very long and deliberative meeting, and that's on purpose. So I think we do better to perhaps next time have a panel of physicians on the pro side, a panel on the con side, and then those panels will we've been contacted by medical professionals from both sides. We'll go ahead and assemble a panel of those, a coalition of the willing, I guess, from both sides, and then those folks will go ahead and be subject to questions from the members, just as the author and the doctor have today. So are there any questions from members of the committee about going forward, about how we're going to proceed? It's pretty similar to what we've done in years past on this type of issue. Okay, with that, let me thank the author, the members, let me thank the audience, and we're adjourned.